Let's talk about marriage fraud and what types of fraud, what do we learn, and what's new as opposed to what may have happened years ago. Well, and I'll start with that. There's really nothing new. You can go back into the 70s, and the very same issues with regard to fraud apply to this day. The immigration law has not changed that significantly. And when you look at whether it's a relative petition or an employment-based petition, you still have the same basic provisions and the same fraud. Now, the big difference, however, is volume, because the volume of applications and petitions that Legacy INS and then CIS experienced tremendous growth, unprecedented growth, of course then multiplies the volume of fraud. And then in a post-911 environment, that's very dangerous. So you have to keep that in mind. So now we go back to the marriage petition. Most common type of marriage fraud indicators. Well, we did always think, anecdotally, because INS never really performed studies and collected this data, but I can tell you as a former immigration adjudicator, immigration inspector, and officer, that anecdotally, and I had experience, as did many of my colleagues, that significant age difference. Or in some cases, they were attorney represented, or who was the attorney, or perhaps even nationality. Certain nationals from certain countries, red flag up the pole. That's how we operated when we had no other intelligence information or no other fraud indicators. And in some cases, it was true to a certain degree. But to step back and look at that nationally and say, make that statement as a national finding, absolutely not. What we've learned in the past several years is that age difference in and of itself is not a significant fraud indicator. In fact, as time has changed in society, you see more and more people married of different ages, perhaps decade or more difference, different backgrounds, different races, different ethnicity. So in the days of old, we thought that was a fraud indicator. So we have pretty much established that unless it's a really significant age difference, it's probably nothing. If it's an attorney, our stats basically show there was as much fraud with attorney-represented cases as there was without an attorney-represented case. With regard to nationalities, when you compare the numbers and the percentage of that particular fraud, that country, to how many applications or petitions are filed by that country, the rates were not significantly different than other countries. And I think where over time many of us thought otherwise, it's because of the volume that we were experiencing without regard to what the grand total of applications and petitions existed to take that percentage from. So once we learn that, what we really have to focus on is credibility of the petitioner and the beneficiary. How familiar are they with each other? You really have to interview them. You have to interview them separately. You have to know in detail their history of how they met, what made them marry, what's been going on, what do they do. But as a whole, you really just have to do a thorough job and you have to interview the individuals. But you have to interview. Now, in the approach, after we did the systems checks, keep in mind our FDNS officers are loaded with this information, so now they're prepared to do the interview. So they'll do a standard interview and ask questions, and the beneficiary or petitioner will lie. We have the information, so then we'll approach them, confront them with the information. Sometimes they do a pretty good job, well rehearsed, and the interview's concluded with, hey, appears to be a good marriage. So then, next step, the FDNS officer goes out and does a site visit. Maybe in the next day or next few days, goes out and do a site visit. Lo and behold, they're not living together. They're nervous as heck. They thought they succeeded in the interview, and a certain percentage of them caught on the spot, admit to fraud, and actually withdraw the petition. And it's pretty clear that when you go knock on the door, you can talk to neighbors, you visit family, you visit the employer, and you ask questions to see if all this is consistent with the information provided to us either in the interview or in the application and supporting documents. So it's a lot of information gathering, it's a lot of information verification, and it takes time. But that's what it takes to identify a marriage fraud case. Now, the types of cases where the foreign national is duping the U.S. citizen, that's extremely difficult because in those cases, they're usually cohabitating, they're usually very familiar with each other, and the foreign national knows, wait till you get the green card, perhaps wait even a year beyond that, let the dust settle. There's a provision in the law that requires another petition to be filed 2 years after you get your green card to remove those conditions. So one of the things we've observed over the past several years is a growing number of very well organized and very well prepared petitioners and beneficiaries. And I don't mean on a major scale of major conspiracy, but even a lesser skill. And I attribute a lot of this to society advancing with technology and social media and all of that, and people were bright. They realized that, look, we're going to get interviewed, they're going to ask us questions, we have to live together, we have to go through the motions, I'll pay you this much more for that, hang in there, we can still have our life, it's going to be worthwhile, here's half up front, here's the other half 2 years down the road. They are starting to be much smarter. Another thing we found in the marriage study is that the fraud, the most significant fraud, was committed by beneficiaries who were legally admitted into the country, that they did not cross the border or they didn't enter without inspection. So, and that's understandable if you know the law, because the law allows individuals who were inspected, admitted, and paroled into the United States to change their status to a permanent resident later down the road. So if you entered as a visitor or in some other non-immigrant category and you married and had a petition and filed and approved, you could then apply for adjustment of status to that of a permanent resident. However, if you were not inspected, admitted, or paroled and entered the border, across the border illegally, you were not eligible. You'd be eligible to have a petition filed for you, but the petition is filed by the U.S. citizen or lawful permanent resident to classify the beneficiary as being eligible for a spouse immigrant petition. It doesn't actually grant the benefit to the beneficiary, the alien. But upon approval of that petition, the beneficiary can then take that approval and apply in his or her own right for the green card. If they were inspected and admitted and paroled, they can apply in the United States, and if they entered without inspection, they have to go overseas. So common sense then dictates that most of your fraud is going to be on individuals that know they don't have to depart the country. So one could look at the law and say, oh, is that a vulnerability in the law? Should we allow individuals who were inspected, admitted, and paroled, but violated the conditions of that status by overstaying their visa, working without permission, whatever, going underground for a couple years, and then popping up, marrying a U.S. citizen, and not having to depart the country? Well, if you changed the law to prohibit that, you would definitely eliminate that fraud. The problem with that is the overwhelming majority of petitions are good, not fraud. So you would really be imposing a hardship on bona fide couples who fell in love and married to have to make the spouse then go overseas. And depending on where you go is how long it's going to take. And you could be stuck overseas for a while. And is it worth making a person go there? I would say not. And focus on the integrity probably as much as anybody, and I'm very concerned about this. I mean, being the architect in chief of FDNS, I think that's probably a little bit too harsh. One of the things that I learned upon building FDNS that alarmed me is that marriage petitions that are filed in the center, with the center, where the beneficiary resides abroad, the perspective in the centers is that, well, they're abroad, we can't interview them, so just approve it and send it abroad. That makes the hair on the back of my neck stand up. I think there are a lot of things you could do in communicating with the petitioner, notwithstanding the fact that beneficiary is abroad. And one of the answers I got in my inquiry into that practice was, well, that's up to the State Department. So one of the things FDNS was looking at, I think at the time I retired, was hopefully changing that practice and not relying upon the State Department. There's no doubt in my mind that before the state issues the visa, they're probably going to do some questioning. But I don't think you want to approve something with an expectation or hope that someone will do a thorough interview. So if we wanted to continue the practice, and I'm not ruling it out, it's one of the things that FDNS is going to study to see what needs to be done, but that has to be resolved working closely with State Department. I think the key point here is, what do you do to the best you can? If I had the ability to wave the wand and say, this is the law from here on out, I would say that CIS must conduct an interview of every petitioner and beneficiary of a marriage petition. And I would say that interview must be done by specially trained people, and the interview must include a separate interview of both the petitioner and the beneficiary. Now, when that interview takes place is another question. We've learned that there's value in doing the interview before you grant the petition, as well as at the time they petition for removal. Now, given the volume of petitions that are filed, especially in today's world where resources are rather limited, that might be a little overkill to mandate an interview at both the initial filing and the petition for removal. I think I probably lean more towards they must have at least had that interview before the conditions are removed. I think that's the critical point, because at that point in time, they were supposed to have been married for at least 2 years. And 2 years of a reported marriage, and have to document that and survive an interview, if it isn't legitimate, would be much more difficult than it would in doing the interview at the beginning of the marriage.